Hello everyone, this is Xiaosheng Huang practicing immigration law nationwide in the United States. I have offices in Los Angeles and Las Vegas. Today I'm talking about the EB1A person with extraordinary ability to apply for green card in the United States or overseas for consular process. First, you need to file I-140 with the USCIS. Right now is all centrally processed in Nebraska Service Center. I think it's getting more and more difficult to get your I-140 approved, even though you can get all the documents to prove that you have met the 3 out of 10 criteria for the EB1A. So people get the green card based on this category would have to actually have evidence to prove to meet the 3 requirements, not only 1. First is 3 out of 10 criteria. Second, you have to show that you will continue your expertise or your employment in your field when you come to the United States. And number 3 is that even though you meet the 3 out of 10, you have to convince the USCIS that you are one of the few in the world who have such accomplishments, which is very subjective. So the USCIS officer think you may be, you may not be, it could he or she could deny your application. The EB1A category is normally for the people who has got a significant international prize like a Nobel or Oscar prize. But if you don't have a major or significant international prize, you could justify you meet this category by meeting the 3 out of 10 categories. Recently, I find it is hard for us to prove it. So the USCIS is very picky about the 3 criteria. Now, number 1, that you could get a prize, but it must be a national or international level. So some people put like a state or province level or city level. It doesn't work. So better to know to present those stuff. If you have national or international, have them. Also, if you have the first prize, present them. If you have second or third prize, even though you are one of the few, the USCIS won't buy that. So that's the first criteria you need to look at. Secondly, you have to prove that what's the qualification to get that prize, and who can apply for the prize, who else earned the prize. So the USCIS will compare you with other people to see you are extraordinary or not. Regarding the judge criteria, you have to show that what's the qualification to be the judge. And today, they even ask the evidence you have judged, that what time, place, and what people you have judged, what work you have actually done. You can't just show a letter of appointment or letter of invitation to you to become a judge or editor for a magazine. You have to show actual work you have done. In terms of the membership, say you have being a member of a very specialized committee, and you have to prove who can be that member, how many members in that committee, and what's the qualification to become a member. You can't just say I'm a member of any association or be a committee or C guild. It doesn't mean anything. You have to prove the criteria to become that member. So regarding the patent, so the USCIS officers say would say that it's so easy to get a patent that you can get a patent registered in any country for many times for many patents, but we have to learn that whether your patent have a significant contribution to the business, to the science, or to the world. So you have to show the application of patents. The numbers of the patent don't count. So you have to justify, you have to document that how your patents will has been used, have been contributing to the society and to the world. Regarding the recommendation letter, so applicants always want to have as many as replication letters presented. But in fact, the US CIS officer want to see the recommendation letter must have not only name but also his address, phone number, email, so they can verify whether this guy actually wrote the letter for you. And in the meantime, even though you present a lot of letters, the CIS adjudicator will say, "Oh, this is the only reference for us. It doesn't have a predictive value." So to prove your contribution to your field, you have to show other evidence like your whether you have original contribution, whether your contribution have been significantly applied in your field. Regarding the book or articles you wrote, they look at the Google Scholar citation, but they want to see further whether you authored the book or article or you just edited. So sometimes the translation is also very important. You have like 20 books, but it's all edited by you. So the USAI officer would say you are just an editor, not an author or not a writer. So you are not able to qualify the 3 out of 10 criteria. So although you met the 3 out of 10 criteria, the USCIS still wants you to prove you are one of the few in the world, on the top of the world, to get such an achievement. It's very subjective. It's like you can say Marilyn Monroe is a beautiful lady, but the USCIS for the USCIS adjudicator would say, oh, she's ugly. So even though you get a 3 out of 10 criteria met, the officer will still say a lot of people can achieve this, and you are not one of the few. So you are not qualified. It's still deny your I-140. So that's why I want to say it's not as easy as you think today when you apply for EB1A as a person with extraordinary ability. Lastly, that you have to prove you come to the America to continue your employment in your field. You can't just say that you are like extraordinary artist. You come here to open a restaurant and become a cook, or you are a famous doctor or a very good doctor overseas, you come here to do some other things to open a like a department store. So you have to be in the medical field or researcher or scientist. And there is also a case law saying that although you are good athlete, that doesn't mean you would be a good coach. So the case law says that you are very good player in your country. You even won the Olympic gold medal, and then you come here, you want to be a coach somewhere. The USCIS would deny your application. They will say, even though you are a good athlete, it doesn't mean you could be a very good coach. So you have to come to the United States to do the work you are good at. You excel. So it's very difficult. You need to find a very experienced attorney to help you prepare the for. Of course, you can help. You can prepare it for yourself, but when you get the denial letter or big facts request for evidence, and you will feel very frustrated. Frustrated. So let me tell you that we handle the F-140 EB1A application, but we do our initial legwork very, very carefully. If you are not qualified, we won't apply for you. Maybe we suggest you to do the national interest waiver for EB2, or we just do EB3, and we don't want to dupe you into the EB1A category. In the meantime, on the market, there are a lot of companies who want to, try to promote you as a EB1A. Be careful. If you provide fake documents, you could be charged an 812A61A. That means fraud or misrepresentation, which will bar you forever from the United States immigration system. Thank you for your watching. See you next time.